This is case number 2006-0113, Frederick J. Murray versus Special Investigation Unit of the Division of State Police of the New Hampshire Department of Safety, et al.
Counsel, before you begin, there's someone in the courtroom this morning that I would like to acknowledge and to tell him what an honor it is to have him in our courthouse. And that is the Chief Justice of Iraq, Madhat al-Mahmoud. He spoke here the other evening and left a lasting impression on all of us. And so thank you, sir, for being here this morning. Counsel, you may proceed.
Thank you, Your Honors. Good morning. My name is Timothy Irvin from the firm of Gallant & Irvin, and I represent the appellant in this case, Mr. Frederick Murray. The issue before this court is an appeal under the New Hampshire Right to Know Law, RSA 91A, of a decision issued by Judge Vaughn denying Mr. Murray's request to obtain records under the provisions of the New Hampshire Right to Know Law and under its federal counterpart, FOIA. And we suggest, Your Honor, that this is a unique position we find ourselves in. The typical cases involving the disclosure of records under 91A typically involves situations where a number of records have been produced and a limited number of records have been withheld by the state under a claimed exemption to the Right to Know Law. And in this case, the entire 2,500 documents that the state claims to have in its possession, none have been produced on the grounds that all of the records fall within a claimed exemption to the New Hampshire Right to Know Law and FOIA. Specifically, the position of the state is that all of the documents are in an investigatory file and therefore need not be produced. And I would suggest that if the court follows that reasoning, the exception would swallow the rule. This court has been very clear in its decisional law that the balance should be that exemptions are narrowly construed and the provisions favored disclosure are broadly construed.
Is it your position that the state has to make a specific showing in this case that disclosure would interfere with an ongoing criminal investigation?
It is, Your Honor. I believe.
How would the state do that without compromising whatever information there is in the file?
Well, Your Honor, in Loge, which was the first decision of this court to deal with records of this type, investigatory records, the court stated at a minimum there should be an in-camera review of the documents that are in the possession of the state so that they could articulate what exemptions apply and how the release of the records would be implicated by one of the exemptions. And in
Who would you have perform that review?
I'm sorry?
Who would you have perform that review?
That would be done by the trial court. In Loge, it said specifically that on going forward on cases, the trial court should require an in-camera review with the judge and counsel to determine that the records that the state is claiming are exempt, in fact, comply and meet with the exemptions.
Why wouldn't that, in those pre-indictment circumstances, why wouldn't that almost be presumptive?
Well, Your Honor, there certainly will be records in the state's possession that would fall within one of the claimed exemptions, but to suggest that all 2,500 records that the state has compiled all fall within that exemption.
The concern, I suppose, is this. What if, with all the investigations underway in the state of New Hampshire, however many there are, but there are multiple, I'm sure, a member of the press said, I would like to get access to those materials, and I don't trust you, so I'd like you to do a Vaughn index or have an in-camera hearing, and we'll go through every single document, and you can justify it. We probably wouldn't have enough time in the courts to deal with that, would we?
Well, Your Honor, I would suggest that there is a balancing that can be struck.
Yeah, but in every individual case, they'll say, well, you can strike a balance in the next case. But you're suggesting that if there's investigation file, the state, document by document by document, in camera, has to explain why it would be prejudicial to release it?
The decisions from this court and the federal courts have stated that it is incumbent upon the state authority to make an examination of all of the records in its possession to determine whether or not an exemption to FOIA or the Right to Know law applies.
But if that's true, then in every case when they say we're exempt because they're investigatory files, pre-indictment, you would say, or whoever has the case, well, thank you for sharing that, but I'd like you to do a Vaughn index, or I'd like to have an in-camera review, so bring the 1,400 pages, and the judge will set aside a day or two and go through them. Is that what you are saying?
I believe that's what the New Hampshire right to know law requires, and I believe that that's what FOIA requires. I believe that the statutes are designed so that there is access to the records of what the government has done. And this court in the Baumann case was very specific when it stated in its language that they were not adopting a per se rule favoring non-disclosure. What it was saying was that in Baumann, because we were at the crucial early stages of the investigation was only 5 months old. It was a very limited number of records that they were seeking. They were seeking the search warrants and the affidavits that were used in conjunction with that. And the court in that case said that you could temporarily withhold those documents.
Well, is it just the 5 months? Is it just the time limit that matters? In other words, are you suggesting that because more time has passed with little apparent development, suddenly the balance shifts?
Well, the balance, Your Honor, is always, my understanding, is always on the state to show that the exemption applies. In this court, in Baumann, used the language.
Baumann, the state showed that the exemption applied, but you seem to think that the passage of less time may have been a critical factor for the decision.
I believe that it was a critical component of this court's decision, and that's why they used the language that in Baumann they said that they would restrict access for a temporary period of time so that the state could have a reasonable amount of time to conduct a proper criminal investigation. In that case, it was 5 months.
What's reasonable?
I believe
you would say that this is not reasonable?
We're coming now, Your Honor, on the third year anniversary of Mara's disappearance. Has the state had sufficient time to conduct a proper investigation into her disappearance? I believe that they have. I believe that there still will be records that the state could show will fall within an exemption, but to suggest all 2,500 records when there has been a zero examination of any of the records in their possession to show how these exemptions apply. This was basically what has happened here, and is what the Supreme Court in the National Labor Relations versus Robbins case said, was simply to needlessly extend a prohibition against the release of any records simply because they're an investigatory file is not in keeping with what the mandates of FOIA are.
Do we know what the state means by ongoing investigation in this case? Do we know what actually is being done?
We do not. The testimony at the lower court was on an offer of proof that there is an officer that examines the case every day.
Is this a criminal investigation?
I don't believe that is clear, Your Honor, because the characterizations of the state when Mara first went missing was that there was 3 theories they were proffering: that she went missing of her own volition, that she had succumbed to the elements, or that she was a suicide victim. And so,
does it make a difference if it's a criminal investigation as distinguished from a missing person?
I believe there is a distinction. The distinction is when, under FOIA, records can be withheld if there's a concern in what the state has raised here that it will affect an enforcement proceeding. So if there is not an ongoing criminal investigation, then the fact that the release of the records could implicate or impinge upon a future enforcement proceeding is speculative, because there is no intended enforcement proceeding at that time. In the court in Eli versus FBI, Your Honor, dealt with this very issue, and also in Chicago versus ATF. In that case, the city of Chicago had requested records from the Alcohol, Tobacco, and Firearms Division. They had assembled records in a database on handguns that had been used in crimes in the city of Chicago. And in that case, the city sought to get access to the records, and the Seventh Circuit required ATF to turn over the records on the finding that to suggest that at some future time they could prosecute an individual based upon the guns that were located in that database was speculative.
Isn't that a factual finding? In other words, as I understand this case, and if I'm wrong, please tell me, I thought that the state had given to the Superior Court a listing of the types of documents involved. Did they do that?
Your Honor, page 100 of the appendix, the state produced a one-page document that has 20 vanilla categories of records that are contained therein without any specificity as to how each of the records which would fall within those broad categories fall within the limited exemptions under FOIA and the right to know.
Your view is that on FOIA, for example, no court has ever made a ruling on this exemption or been allowed to make a ruling on this exemption without a Vaughn index and some sort of in-camera hearing, document by document by document.
I'm not suggesting, Your Honor, that has never happened. There are certainly the Dickerson case
Is that the usual way these cases are resolved, or is the usual way the way it's resolved here? In other words, the court made a finding here, as you know, that it would likely interfere. And it seems to me that's a factual finding, and you're saying the court did that on inadequate information. And my question is that how it generally occurs? The law enforcement authority says these are the types of documents we have in our file. To disclose them now would interfere with our investigation of this crime. And the courts say, I accept that, or I don't accept that. Is that how it generally happens?
My understanding from reviewing the cases, Your Honor, in the Cucci case versus FBI, in Eli versus FBI, those cases speak specifically to the exhaustive search that was done by the underlying departments, FBI, DEA, to comply with the requests that were made to those organizations. And then it talks about the significant, they always list the number of records that have been produced, and then talks about the narrow number of records that are not being produced under some claimed exemptions. And the court make note of affidavit testimony. It takes testimony from witnesses that were in charge of assembling the records to show the detail that these various agencies engaged in order to show that they made an exhaustive search to produce all records which were not exempt, and to show the good faith basis to suggest why they've met those specific grounds which would prohibit disclosure. And in this case,
let's say, for example, there are reports on physical evidence that was recovered, whatever it is, and the state says we have reports on physical evidence that was recovered, and if we release this, it would interfere with the investigation. Is that sufficient?
I would suggest that they've met their burden at that point in time, Your Honor.
And how about if they say, well, we have witnesses that we've interviewed, and they've given us information. If we release that, it would interfere with the criminal investigation. Would that be sufficient?
I would think that it's still, Your Honor, I would think that at a minimum there should be some sort of in-camera review to suggest.
I don't want to get to in-camera review yet. I'm saying that, so you're saying that would not be sufficient if the state says the witness interviews would compromise our investigation?
I would think that the burden, and it's clear under the case law, the burden is on the state to show how the exemption applies, and it would be up to the reviewing court to determine whether or not the state has sufficiently met its burden to show.
But you're saying on my hypothetical that would not be enough?
In some instances, it would not be enough, Your Honor. It would be.
So a court gets involved in making qualitative judgments about the nature of the prosecution at that point, and what is prosecutory or what is investigatory and what isn't. Isn't that an impermissible intrusion? If we are dealing with a criminal investigation. Say witness interviews.
And again, I think that is why this court in Loge said at a minimum that there would be this in-camera review. One of the cases that was cited in my brief that I would like the courts to consider is that Eli versus FBI case, where it was the exact same case in front of the 11th Circuit, where the state had denied access to any of the records, had provided no Vaughn index, had provided no list of the types of documents it had. And the 11th Circuit said in that case, where you had simply no hearing, no minimal showing of how the claimed exemptions applied, no in-camera review by a court, it gave the government an unfettered check, and the 11th Circuit found that violated FOIA, that at a minimum, there needed to be a review and the state to establish how, with specificity, how all of the records that they claimed were exempt fell within the exemption.
On page 100 here, where the state disclosed categories of records, without asking you to go through those, are some of those on their face acceptable to you, or does the court have to get a Vaughn index on every category listed?
Your Honor, it's difficult to say because, again, if you look at the categories of documents here, phone records, it's a generic term. There were a number of phone calls that Mara made prior to her disappearance. And the burden is on the state to show calls that they would have in their possession that predate the disappearance and any investigation fall within the claimed exemption. That it's difficult or impossible for us, and the burden isn't on Mr. Murray to establish that the exemption in fact applies. That burden falls upon the state. And without having had any meaningful review by a reviewing court to suggest how these various categories of documents all fall within the claimed exemption.
How many documents are involved here, do we know?
My understanding, the representation, Your Honor, at the trial court was the state had assembled 2,500 records.
Okay. So just so I understand what you envision a hearing held. You're not at it?
I'm sorry?
You're not at the hearing in camera? Who's at the hearing?
My understanding that the in-camera hearings are conducted in the presence of counsel, Your Honor.
So
it would be
you'd
the
be
trial judge, it would be a representative from the state, and it would be counsel for Mr. Murray would be present. Or I believe that the court has the right to fashion the in-camera review and make its own determination outside of the presence of counsel to determine whether or not the exemptions that have been claimed.
So the trial judge would be required, in addition to whatever else they do every day, which is considerable, they would have to go through cartons and cartons and cartons of boxes, either by themselves or with some combination of counsel present, to understand what it is before they calculate whether it's subject to the exemption.
Your Honor, and when I use that word require, that language comes directly out of this court's decision.
No, I'm just asking.
That's what you said. You required to determine whether or not there is a total or a partial withholding of the record.
No, I understand that. I'm just trying to get you to either agree or disagree. What I've laid out as a scenario is what the trial judge would have to do.
That is correct.
Okay.
And I believe that's what the requirements of the New Hampshire right to know law are, of Article 1, Section 8 of the New Hampshire Constitution, and I would suggest that that's what the requirements are under 5 U.S.C. 552b7. They are required to do that exhaustive investigation, to look at its files, to take those records and segregate those records which are not subject to a claimed exemption and produce them, and then to establish with specificity those records which they claim fall within the exemptions, and then the court has the right to review that to determine if the claimed exemption is in fact valid.
And then if it's appealed, do we review the documents ourselves? If the trial court says you don't get this and you appeal it, we then sit as a trial court and look at the documents ourselves? How does that work?
I would believe, Your Honor, that it would fall under the court's normal review of factual decision, and I guess it would not be disturbed unless it was a clear error of law.
But how would I know whether the court's factual conclusion was correct if I didn't review each document that they kept from you?
Well, again, factual determinations are reviewed on an abuse of discretion standard, and I would suggest that would be the review at a minimum, some court would have reviewed what the state is doing, which is the whole purpose of the right to know law.
No, I understand.
For citizens to look and see what they're doing.
Factual issues come up here. We look at the record to see whether the record would support the finding. So if a judge says this document is not to be given, if that's a factual finding, I can't wear a blindfold. I have to look at the document, don't I, to say a reasonable fact finder could conclude.
Correct.
So we would have to review all the documents here.
I believe that that's the possibility, Your Honor. It would be, I would assume, submitted under seal, and the court would then consider it as part of its overall review of the record.
All right.
And I see that I'm out of time, so if there's any other questions.
Thank you.
Thank you.
Good morning, Your Honors. I'm Nancy Smith. I'm here today on behalf of the state of New Hampshire defendants, as well as the county and municipal government organizations that were named as respondents here. And first, I would like to say that we empathize and sympathize with Mr. Murray's concern over his daughter. I can't imagine a father that wouldn't be concerned about the disappearance of his child. But when we consider whether a record is a public record under 91A, we're not allowed to look at the relationship of the person who is asking for that record to the subject matter of the record. Although we don't in any way suggest it's the case here, what we are being asked to do in this case would open up the state of New Hampshire law enforcement investigatory files at a pre-indictment stage to the suspected perpetrator as well as to anyone else in the world.
Shouldn't the state at the very least concede that it's a criminal investigation? I gather the state hasn't even done that.
I'm sorry, I didn't quite hear your...
It's my understanding that the state has not even conceded that this is a criminal investigation. Shouldn't that be the least the state should do as a premise underlying the problem?
Okay. Because of the facts of this case, we don't have a body. We can't say for sure if Maura Murray is alive somewhere. We can't rule out that she may have left of her own volition. So we cannot, for with 100% certainty say that a crime has been committed.
How does it interfere with a law enforcement proceeding? How does the disclosure interfere with a law enforcement proceeding?
We do have information that we are pursuing that this may involve a crime. And as with any possible homicide, if that's what this is.
Is that the burden the state has, that it may involve a criminal investigation, or does it have to say it will interfere with an ongoing criminal investigation?
The standard is whether there's a reasonable likelihood. We don't have to prove with 100% certainty that what we are investigating involved a crime.
How would the trial court here, I've looked at the list on page 100, and I've read the trial court's finding, which says the court finds that they should be exempt, the documents, from disclosure because production of the records would clearly interfere with enforcement proceedings. First of all, what enforcement proceedings would it clearly interfere with? And secondly, how would you know that by just looking at those broad categories?
Looking at the facts of this case, we have an identified individual. So this is a lot different than the Chicago versus ATF case where you're talking about data about lots of handguns, whose disappearance is being investigated. We have specific records related to the events surrounding her disappearance.
Is that a law enforcement proceeding?
Yes.
So it's a missing person?
It is a missing person who we are investigating whether or not a crime is involved in connection with that disappearance.
How would the disclosure of maps and diagrams interfere with the investigation?
Her car was found. I have not reviewed the specific map and diagram, but I'm assuming that it involves the area in which the disappearance occurred.
Sure.
There were searches done. There may have been maps done of the area searched and what they found, or the point to which they could trace her, because as I understand, the dogs did trace her scent for about 100 yards. And that information, as far as the specific spot in which she disappeared, if they have a suspect, if there is foul play involved, knowing exactly where we determined the last place she was, could be valuable information to that person.
Is that what the record would support, to support your burden, to show that there's a reasonable likelihood that this is going to interfere with a law enforcement proceeding on that issue? Isn't that your burden?
Yes, and it is our position that we satisfied that burden with Judge Vaughn. We produced, based on that detailed review of the records, in order to categorize the documents that we have and place them into these 20 categories. We did a detailed review of all of those documents. At the hearing, Attorney Mullen from our office, who I wish was here today talking to you in place of me, since he's more familiar with this case than I am, he brought with him the chief of our homicide unit, Attorney Strelson, who has been working with this case, as well as Chief Giacone, who were available to be put under oath and testify to the judge, and an offer of proof was made that these records were actively being used in investigating this case.
If that's enough, then you can never penetrate that wall. How do you penetrate that wall? If you're, like the father in this case, saying, I want records, and the police come in and say, well, we're using all these records, and the judge says, well, if you say you're using them, I guess there's nothing I need to do here. Well, what's the judge there for? To find out whether they believe the police or what?
I believe that counsel could have requested that Chief Giacone and Attorney Strelson be put under oath and their testimony be placed on the record.
But they're not going to disclose, are they, under oath? Well, why would they do that? Why would the court say, well, you can't see the documents, but you're free to ask them what's in the documents? They're going to say, I'm sorry, I can't tell you. It's going to interfere with ongoing investigation. So to go back to my question, if the judge isn't looking at the documents, but merely accepting the credibility of a police officer, then the answer to my question is you never penetrate it.
There are,
And if that's true, and it probably is, because you can't think of an answer to the Chief's question, how much time passes? In other words, if 5 months is okay under Bowman, but otherwise, if we say it's, subject to the exemption, nobody can penetrate that, 2 years, 3 years, 10 years, what?
well, as an example, and this was also mentioned to Judge Vaughn at the hearing, our office has recently been able to bring indictments and bring to justice people in 2 20-year-old murder cases, in the Knickerbocker and Windhurst cases.
You're suggesting that the rule should be on basically closed file. Miracles happen. On a 20-year-old file, you think you could go to court and the police could say, well, we haven't totally given up, Judge, and it could interfere. You never know. Of course, I was here. It probably could interfere if you tell me that. I mean, how does one ever get to the document?
An example in the cases that is cited is the Dickerson case, which is the Hoffa disappearance.
We still haven't found him, have we?
Pardon?
We still haven't found him, have we?
We still haven't found him. He could be alive somewhere, although I think he'd be quite old at this point. But the court in that case upheld the withholding of documents in a very old disappearance.
Is this case any different if it's a newspaper making the request and the victim is a high-profile governmental official?
Which is basically the situation in the Hoffa case, I believe.
I don't know if he's a governmental official, but he's high-profile.
Right.
But I mean, it's a case where there's not just a family that's interested, but there's general public interest in the disappearance. Is it a different case? A different balancing?
The sheer volume of documents in that case, if they had a collection of things that were otherwise public, like if they had a collection of newspaper clippings that were sitting in their file, those documents that are public that aren't.
I understand that, but where there's a heightened public interest in the disappearance of someone, shouldn't there be a more liberal standard of disclosure?
I believe that the obligation on the government is to protect we have conflict. We have two obligations. We have an obligation to comply with the right to know law, but we also have an obligation to bring to justice people who have committed crimes. And we have the obligation to look at our file and make sure that releasing information from it is not going to harm our ability to bring people to justice.
Let me go back to the Chief's question earlier. Putting aside the fact that there are 2,500 documents here, I mean, the volume doesn't matter, whether it's 3 documents or 2,500 documents. What's to be lost from having a judge look at them ex parte without counsel present to determine whether or not they should be disclosed?
The loss, as Justice Broderick has suggested, is a burden in potentially every criminal case in this state, and the judge being asked to look at volumes of documents. And I would point out that the cases that we have cited do not say that in-camera review, and that's very clearly stated in the Eli case that my colleague cited. The in-camera review is to be rare. And it is to be reserved for those cases in which the exceptions claimed are few and the documents are also small, and that it is the exception rather than the rule.
If you don't do that, and if you don't have if you don't look at the in-camera review and you don't have a Vaughn index, then all you're doing is relying on the representation of the prosecutor, whatever. The judge, this is an investigation, and disclosure will likely interfere with the process, right? Isn't that right?
No, Your Honor. We do have the obligation, which we fulfilled in this case, and it's contained in that categorical listing of documents on page 100 in the appendix, there are 20 categories, and just to read a few of them, there are phone records, there are subpoenas, there are credits, there are credit card information, criminal records checks, narrative reports by the investigators, witness interviews, tapes and transcripts of that. And if you look at particularly the Wright versus OSHA case, there were in the Wright versus OSHA, the government segregated its documents into 5 categories.
Well, how does that help me? How does that help me make a determination that the disclosure will reasonably interfere by just telling me that I've got 20 categories of documents? How does that help in any way?
Because you can see from the types of documents which are identified in these categories that these are the types of documents that if this develops into being a homicide or criminal case, might well be evidence or might well be supporting or corroborating evidence that the government would need to keep confidential in order to prosecute its criminal case.
So your argument is that you can infer from the nature of the evidence itself that it's relevant evidence in the criminal investigation?
Yes.
Does it matter if you have an investigation, not this case, have an investigation where you think there's a disappearance, you the parent, and the local police department is not that focused on it, but they've done some investigation. But if there's a disappearance, you don't think there's foul play, you just think that something happened for other reasons. And they're not really taking a hard look at it, but it's an open file, and if they get to it, they get to it. But you think time is critical here, and they may have learned something that you wouldn't know, but you'd like to follow up on it. Doesn't matter. If it could interfere with an investigation, however slow-moving, however back burner, and however mental health oriented in my hypothetical, doesn't matter. Right?
Your Honor, the police and the government have the discretion in a case like that where they don't believe there's any evidence or any possibility of there being a criminal investigation to release the information to Mr. Murray.
Let me ask you this. What do you do? I just don't know how you penetrate it. A police officer comes in and says, you're right, it's been 18 months. We think it's a missing person, but it could not be a missing person. We haven't given up on it. And every single piece of paper in our files, if we disclose it, might interfere with an investigation. The court says, what? Thank you for sharing that. I guess there's nothing I can find out. Well, what does the court do? What does the judge do that the officer hasn't already done? It sounds like nothing. Why is it in court in the first place?
I'm sorry, I'm just not understanding your question.
What is the role of the judge in a case like this? Police officer says it's ongoing, we don't know whether it's criminal, we don't know whether it's a missing person, I haven't looked at the documents, says the judge. What do you think, officer? Oh no, they're all privileged, judge. Here are the broad categories. You can understand broadly why that would be a problem. The judge says, well, thank you for sharing that, end of case. Doesn't the judge say, well, maybe we should look at some of that? Because there may be differing views on that.
In this case, if that were the case, then the judge could demand an in-camera review. The judge has the option of doing that. I do not want to suggest that Judge Vaughn could not have said, I want to see the documents. He could have said that. In fact, Attorney Mullen offered that to him, and he felt it wasn't necessary, that the showing that had been made to him, if you read the transcript, you'll see that offer was made to Judge Vaughn.
What exactly does monitoring, a detective monitoring the case each day mean? As I understood it from the record, that's what the state says the investigation amounts to these days, and I don't know what that means. I talked to Attorney Strelzin yesterday about whether or not the investigation was still active. He did indicate to me in some specificity that there are currently activities going on, and that this is very much an active case. But at the time the matter was put to Judge Vaughn, I could be wrong, memory might fail, the offer of proof was that every day a detective monitored the case or developments. And does that mean asking somebody if anything's happened? Does that mean doing what does that mean? You don't know? It's okay to say you don't know.
It's more than just looking at a list of cases and say, okay, has anything happened on the Murray case? No, and going on to the next one on the file. It's more than that.
Okay, thank you.
So I believe that this court should affirm Judge Vaughn's order, finding that these fall within the law enforcement exception that they would potentially interfere with a enforcement action to protect the government's ability to bring to justice or to be sure that justice can be achieved for Maura Murray in the event that this turns out to be a criminal matter.
Thank you. The case submitted. Case submitted. The court will be in recess.